Representative Bennett, you're recognized for a question.
Thank you, Mr. Chair. Mr. Ballinger, I spent a lot of time reading this last night, and some of the things I'm just having a little trouble working through.
Sure.
And one is the definition of a compelling governmental interest, and we use the governmental interest of the highest magnitude, and I can't find that in case law. I can't find that anywhere else in statute. I mean, what do you think that means?
Essentially, it just means that there's some important reason to do it. So, and obviously that's not one of the amendments, so it's the issue that maybe could have been covered before. But it just basically means that it's an important right, essentially.
And if I might have one follow-up.
Important issue.
You're recognized for a follow-up.
Okay. On page 5, one of the amendments added in what appears to me taking away our sovereign immunity.
Okay, no, it didn't. That was actually part of the amendment offered by the governor's office, and what it provides is clarity. What they had some concern about was whether or not the state could be made a party to an action, irregardless. The language from their perspective wasn't clear. They thought maybe the state could be made a party to an action, even when the state was not or the state would be required to pay to pay damages even when the state's not a party to the action. So the original bill would say, and in fact, let me say this, it's not necessarily my bill that waives sovereign immunity, it's civil right that waives sovereign immunity. So anytime you have a civil rights claim, there is no immunity for the sovereign. However, what we're doing is we're creating a little more protection for a person's civil right. And so you could say that maybe there's a little more liability from the state perspective, which is really what the intent of the bill is to make it where state action doesn't burden a person's belief and doesn't prohibit them from carrying out.
Terry Bean's about to lose again.